First matter on today's calendar is number 116, People versus Dayshawn Crooks. Counsel.
Good afternoon, Your Honors. Your Honor, may I request 2 minutes of rebuttal time?
Yes, sir.
Thank you, Judge. Your Honors, my name is Matthew Hugg. I represent the appellant, Dayshawn Crooks. It is the appellant's position that the trial court erred in denying the appellant's request for a Darden hearing, which is a very minimal hearing that does not impose too much on the court or on the identity.
Well, you've read your opponent's brief. Wasn't there a basis for the search warrant besides any claimed CI?
No, I don't believe so, Judge. I think that what the people are hanging their hat on really is the second controlled by. I don't think that their argument has any weight with respect to controlled by number one, because that one took place entirely in the home, which was a multi-unit building. At best, they heard audio, but without the CI to say this transaction occurred in the defendant's apartment, or as opposed to a common space or one of the other units. There was no evidence put forward to either the Superior Court or the local court that issued the warrant that this was the defendant's voice. There was no voice recognition evidence put in. Flatly, it's a Hamilton type case from the 3rd Department where it entirely happened inside the building and without the statements of the CI.
What about the second by?
The second by is more arguable, I will admit, but I still think that there are significant holes that would have required to be filled in by the CI, namely.
Well, and all you need is probable cause, right? So
yes, all you need is probable cause.
Proof beyond a reasonable doubt.
Right. I agree.
So what are the big holes?
Well, the whole is that the CI leaves the visual of all the members of the surveillance team, according to Wood. So for a period, he's unseen. He makes a telephone call, but there's no evidence to substantiate what telephone number he dialed while he's outside of their visual. They say that he called the defendant and someone changed the meet location. And then there is a meet, but while the officer testifies that they saw interaction, there's no testimony in the record that we saw a glassine envelope or we saw anything.
But they search him, the CI, before he goes into the meet, right? And then he's in their line of sight until he has the meeting, and then when he comes out, they search him and he has the drugs.
This is on the first one?
On the one you're just talking about?
On the second one, no, they lose visual of him entirely, of the CI.
But they do have audio recording of him throughout, right?
Yes, they're listening and recording audio of the on a wire that's attached to the complaint.
You know, the underlying purpose of Darden, of course, is to establish that there is a confidential informant.
Yes.
And that seems pretty clearly established in the absence of a Darden hearing here. And so I thought to myself, well, maybe the observations themselves, there were some verbal observations on the second by, but some of it was nonverbal, and it doesn't seem to be that you would really draw any distinction between those. So on that spectrum of cases, from Farrow to Adrian, where would you put this?
I would put it closer to, well, Farrow and Adrian. One is a continuous observation, and we don't have that because, according to Wood, we lose visual of the CI. Mm-hmm. It's not Farrow because Farrow is really not relying on the CI much at all, aside from the tip that a drug deal was going to go down at a particular location. So when the police watched the transaction and they actually testified that they saw 1 or 2 pink glassine envelopes and then an exchange, that was enough for probable cause.
You're talking about Farrow now. I guess the question would be, what about this case would make us question the existence of the CI that couldn't be sustained by the simple observation of the police officer seeing and hearing what he was doing?
Well, I think that you're going solely on an audio tape, which I think is troubling. You know, even if this court doesn't find it's troubling in this particular case, it should be troubling as a rule that an audio tape can substantiate the existence of a CI, especially under circumstances where the police are, I mean, in this case, the prosecutor initially told the Superior Court there wasn't a CI, comes back and says that there was, and then we have, also keep in mind we have a procedure in place that if the people have audio and they want to try extrinsic evidence, this court has provided that in a situation where the CI would be exposed by a Darden hearing, they can bring that to the attention of the Superior Court and provide evidence that the CI is unintentionally unavailable, and then they can use extrinsic evidence like an audio tape.
Did the judge have the audio tapes? The judge that authorized the warrant?
It appeared like that as such in the record.
It doesn't to me, because it just says proof by affidavit having been this day made before me, and he goes on, and then he says, I'm signing this warrant.
Yeah, the people represented that the tapes were attached to their application, the audio recordings. I don't know that Judge Carter actually observed or listened to the audio. But I don't think that those audio tapes, especially when it comes to the Superior Court now, because in Chisholm, this court said that it was even improper for a court to deny a reading, for the Superior Court to deny the request for a reading of the transcript of testimony provided by the CI to the local court at the time the warrant was issued. So I think that what we're talking about...
So in order to avoid having the CI have to come testify, what would be necessary to prove his or her existence if an audio tape doesn't do it?
Well, in this case, I don't think that the audio tape necessarily establishes probable cause with respect to the defendant. Whether
That's the second issue.
Right.
But as far as the existence of a CI, just
Right.
following up on Judge Fahey's.
Yep. You have the existence. What does the audio tape really show you at the end of the day? It shows.
No, my question is, what would you need to show aside from bringing the CI in to testify before the court? How would you show the existence of a CI?
Under these facts, I think it would be very difficult.
Well, under any facts.
Well, I think, there must be a way for the people to do it without presenting the CI himself. Audio, maybe some kind of video. I mean, video is
You just
easiest.
said that they had the audio.
Audio plus, video would, to me, in this day and age, be kind of unforgivable in a case like this.
No,
not
but
to
I
use
mean,
video.
when I was looking at the affidavit and then the warrant itself, the warrant says it's based only on the affidavit. It doesn't say only, but it says based on the affidavit.
Right.
You tell me that in addition to this affidavit, there is also, the judge had audio tapes.
That's my understanding.
That proves that you got a CI. Why do you need a Darden hearing?
Well, because the Darden hearing goes beyond just proving the existence of a human being. It also, you need to get from the CI that this evidence that he says that he met with. I mean, let's just look at.
Doesn't the conducting of the MAP hearing and the findings of credibility that the judge made and the findings, doesn't that sort of render the Darden hearing academic?
I don't think so, because what you still have is Officer Wood saying what the CI told him. So what you have really is kind of a mystery to the defendant. And I think that at the end of the day, what a Darden hearing is very, very minimal, and it takes away some of the cynicism that many defendants have about the criminal justice system.
That's what I keep asking. Maybe I'm being misunderstood. If the officer says, I have a CI, and that's where I got my information, then we need a Darden hearing, because we've got to make sure he exists. If he says, I got a CI, and by the way, here's the tapes that from the audio he was wearing when he made the buys, you don't need a Darden hearing.
I disagree, Judge, because...
And you disagree for what reason?
I disagree because on two reasons. One, I don't know that it establishes the existence of this CI. I just know that it's an audio tape, or the judge that's issuing the warrant. And two, the audio in this case and in other cases isn't going to have the defendant saying, my name is Dayshawn Crooks, I'm about to tender you.
No, but you even said that Darden's a minimal thing. It's just to prove that there's a CI.
And to establish what he said establishes probable cause for the police. In other words, there's a hearing. The judge doesn't clap eyes on the guy and
What
say, okay.
did you mean then when you said a Darden hearing is very minimal?
It's minimal insofar as it does not require the people or the police to expose the identity of their CI. It's in camera. It can be done at any time.
That doesn't mean minimal.
I think that that's extremely minimal when you're defending someone that's accused of doing something with a CI that doesn't, in many cases, ever get to see who was accused.
What strikes me, it seems like you're pushing the requirements of a Darden hearing more towards Aguilar-Spinelli, where you're talking about the reliability of the informant as opposed to the existence of an informant, to make sure that there really is such a person.
just this past month, this court stated in People v. Joseph that the holding of a Darden hearing is to ensure that the confidential informant both exists and gave the police information sufficient to establish probable cause. So there is somewhat of a blending of an Aguilar-Spinelli, but it isn't a complete Aguilar-Spinelli, and there are cases that state even when Aguilar-Spinelli is satisfied, does not mean that the Darden hearing issue is satisfied. I mean, they are separate, and, I'll agree that there is some blending.
Thank you,
I
Mr.
see my
Kelly.
red light is on.
Counsel?
May it please the Court, my name is Brittany Grome. I'm an Assistant District Attorney in Albany County. I'm here on behalf of the people of the State of New York, the respondent in this case. This Court should affirm the Third Department's holding that the direct visual and audio observations of the trained police detectives during 2 controlled by operations provided sufficient probable cause for the issuance of the search warrant in this case, independent of any information supplied by the confidential
What
informant.
about losing visual track of the CI?
I submit that the record shows that they didn't lose visual track of the CI in this case. If you actually look at the search warrant application, Detective Wood affirms that the CI in this case, under visual surveillance, arrived at the meet location, met the defendant in this case. He exchanged a quantity of buy money for crack cocaine, and then under visual surveillance, he walked back to police custody.
Are you relying at all on the first buy?
Yes, I am. I think the totality of the 2 controlled buys together is more than sufficient to establish probable cause in this case.
Both of them, counsel, you couldn't do it with just the first buy. It has to be both of them.
I submit that the first buy in this case, there is testimony. I think that Detective Regan saw the defendant walk to the top of the stairs, and in this case, it's not a multi-unit, but it's only 2 apartments. There's one on the first floor and one on the second floor. So if he observed him walking to the top of the stairs.
But what stairs that he observed him walking? Was it the stairs of the building or inside the building up to the
Right, that's
apartment?
unclear. He doesn't specify which stairs he saw him walking up to. So I guess you can make an inference that it's either stairs up to the apartment, presumably. But assuming that he couldn't just pinpoint to that specific apartment, then the second controlled buy absolutely comes into play for the totality of it, because this is a search warrant of the apartment and not the arrest of the defendant in this case. So we're not trying to necessarily pinpoint the defendant. We're trying to make a connection to the apartment in this case. So based upon the totality of both buys, there was sufficient probable cause based upon those independent observations. You have an informant who was searched. He's found to have no narcotics on him. He's wired. They are able to listen to the live radio transmissions.
Are the tapes, is the question of whether the court had the tapes critical to the analysis?
Not in this case, given the fact that they weren't relying on any hearsay information, but they had their independent observations. I think if this court were to find that they were relying on hearsay information from the informant, a Darden hearing would have to be held, and then the tapes would come into play as to the existence of the confidential informant in this case. But I submit that it's not even relevant given those independent observations of the detectives.
But did they?
Go ahead.
I'm sorry. Did they have the tape? Did the judge have the tapes when he signed the search warrant?
The search warrant application says that the tapes were submitted with the search warrant application. It does indicate that. I think it's page 49 of appellant's appendix that says that they were provided to the court. Whether the court reviewed them, I don't know, but they were made available. So really, that's all that
As part of the
matters.
application for the warrant.
Correct, Your
Well,
Honor.
does it say they were given to him or that they were made available? And is there a difference?
I think it says that they were made available and attached. I don't have any other information with respect to that.
It says they're based on information and belief. The sources such as information and belief and grounds are a quantity of crack cocaine, and then it says number 2, audio compact disc held as evidence.
Yeah, so I guess if the judge wanted to see them, they would be available to him. I guess they weren't necessarily presented to him in person. But they did exist, and if this court did find, which I submit they weren't relying on hearsay information, but in the event that they did rely on hearsay information from the informant, those would be a way of proving that the informant exists in this case, and therefore a Darden hearing wouldn't be necessary.
What about the fact that the police didn't observe an actual exchange of drugs or anything, that packaging of drugs or anything like that? Is that a problem?
I submit that they did. I don't think it's fatal here. I think the record does show, based upon the search warrant application, that they did view an exchange of drugs for the controlled by money.
They said they saw some kind of transaction, right?
Right. The search warrant application does specifically say that under visual surveillance, they observed him there, he met with the defendant, and he exchanged a quantity of crack cocaine for controlled by money. And then he returned back under visual surveillance. I think Detective Wood's testimony can be inferred in a different way. Detective Wood, if you see on page 63 of the appellant's appendix, he makes reference, well, when the informant was out of our view, the eye detective picked him up. So I think you can also read his testimony with respect to the second controlled by in the same way. When he was out of our view, he's the confidential informant handler. He wasn't the eye in this case. So he didn't directly view the controlled by the actual transaction, but there was an eye detective involved in this case.
So let me ask you the question that Judge Fay put to your adversary on the Adrian and Farrell spectrum of cases. Where do you think this one fits?
I think it fits directly with Farrell. These are independent observations which reach the level of probable cause. This case, and also I wanted to distinguish People v. Hamilton, if I can, which I think relies on Adrian. And People v. Hamilton relies on the fact that because police arrived at a specific location, they wouldn't have been in the position to make any observations, and therefore without the information supplied by the informant. And Hamilton directly says that. But People v. Farrell rejected that and said it's irrelevant why the detectives arrived to a specific location, so long as their independent observations when they got to that location reached the level of probable cause. And I submit, based upon the known facts and circumstances in this case, they orchestrated these controlled buys. They were present for the phone calls. There was visual and audio surveillance. They heard all of the interactions. So whether or not they actually observed the hand-to-hand transaction, or whether they just saw an interaction and they could tie it to the apartment, because they did during the second controlled buy watch him leave that apartment and directly go and meet with the informant, that's enough. That's enough. They're not relying on anything provided from the informant in that case. And so that's why I submit that People v. Hamilton is not necessarily relevant, and People v. Farrell rejected the claim that that Farrow set forth. And if there are no further questions, thank you.
Thank you. Mr. Hung?
Yes, briefly. At the end of the day, I think none of us can really say that this CI, we know beyond a shadow of a doubt that they existed. That is why
her point is that it doesn't make any difference.
I know that. I think that that's a bridge too far. I think that that is not a meritorious argument to make. If
the police saw someone going into a house and coming out with drugs, and they saw that happen twice and said, we think that there's drugs in the house, isn't that enough to get a search warrant?
Hamilton says no. That's a third department case. I will read to you a portion of Wood's application in support of the search warrant, in which he states, the CI provided the following details regarding the purchase of crack cocaine from the target. The target opened the door, and the CI entered the common hallway. Both walked to the second floor apartment. The target removed a large quantity of crack cocaine. The target then handed the target the pre-recorded APD currency in return. The only person that could have, if that's true, told them that is the CI. That is why we have a Darden hearing. Why keep defendants and defense counsel in the dark and potentially allow a...
That's not the only transaction. There's another transaction.
There's a second transaction.
With it. Yeah.
But that second
I'm trying to understand when you think, when there's a CI involved at all that provides any information, when you think a Darden hearing wouldn't be required.
In a situation like Farrell, where the CI merely tells them where something is going to occur, and they watch and observe the crime itself, they see the controlled substance. They did not in this case. We know that the...
And if we disagree with you, then
Well, if you disagree, I guess it would be on the facts of this case. It doesn't fit within a Darden. I would hate to see a rule that makes it even more difficult. Already, the protection to the people is the Darden hearing, and now we're going to even move the ball away from the defendants even further. So already, in most cases, the CI has never revealed under the pretext that all CIs are in danger. Now we've given the Darden hearing as a fail-safe. We also have an escape valve in the event that the people can establish that the person is under threat or is unavailable due to sickness or death, that we can prove with extrinsic evidence, something they chose not to do in this case, so they can't do it now. And now we're saying, we need to, so long as we provide an audio tape and say this, oh yeah, this is him and this is that, even though it doesn't establish any background as to what the CI told them, because they're not relying on the audio tape, they're relying on what the CI told them. They can't do anything with the audio tape alone because on its own, an audio tape of a transaction isn't going to have anything incriminating, at least to a specific individual. It requires that explanation from the CI, and in this case, they needed that explanation because they didn't see the first one, and the second one is cloudy at best and leaves open the possibility that while this person was out of their visual, which he was, if you look at Wood's testimony closely, and made a telephone call to someone that they could not have established to the court on their own as to who he called, and then there was some kind of interaction at a distance. Look, if the people want to avoid Darden hearings, the way to do it is to videotape these things and provide them in camera if they want to do that.
Thank you, Mr. Hook.
Thank you.